Hello, loveys. How are we? Testing. 1, 2. Can you see me? Am I here right now? Are you here right now? You say, "Oh, Kim, it is Monday, May 26th, 2025 at 9:19 p.m." Okay? Where have you been, Kim? Having to move this stream? What are we doing? What are we doing? That's what you were saying. I got it together. And hopefully, this is going to be a stream queen that we all remember. Look at, oh, Annie from Southie goes, "Good evening, love muffins." We're all together again. We're here. Yes. And we are not here for the kayaking of Phil Tensor. I'll tell you that right now. But we are on WBZ5 or WCVB rather. WZ, whatever. WCB is channel 4, but now we're on channel 5. And we're going to turn back the hands of time, loveys. And we are going to go to what Karen Read, the jurors must have considered in their deliberations going back to trial 1. Now say, "Kim, what the fuck are we doing this for?" Okay? On Happy Memorial Day Monday. And I'm saying we're going to go over this, babes, so that we're able to go through all 3 charges. And I was inspired by the lawyer, Peter Tragos. Peter Tragos. He was on with Runkle, and they were talking about, had the Commonwealth actually proved specific elements? Okay. And I say, no, they haven't. Hold on, babes. We're going to go down to standard definition and see. Okay, I might be cooking with gas a little more here. All right. Yes. Kelly, if Chloe bit, you must acquit, knows it's Tragos. Period. And we love him. It was a great video, says Nola CPA. Bethany is like, yes. This sparked something inside of me, babes. You know how I get. I was like, oh, right? I said, have they proved an element? And we're going to be as objective as humanly possible. And I was trying to get like mass.gov and all of the actual criminal statutes, but then I found this by Phil Taser, a digital media manager man, and he has all of the information from trial 1. And it is still the 3 charges because, unfortunately, although Karen Read was acquitted by the entire jury in trial 1 on counts 1 and 3, it was never recorded. So here we are, back to square frickin' 1. And we need to know what is included in each of them in order for the jury to convict Karen, or will we be having freed our Karen Read, which I think we're almost there, babes. I think we are at the precipice of freeing Karen Read. And it is very interesting, and we'll talk it out together because this is what we do. But it says we're going to go, the top charge facing Read is second-degree murder, which carries a maximum penalty of life in prison. In order to prove the second-degree murder, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. Loveys, do we think that the Commonwealth, after 20 days of their case in chief, have they proved that Karen Read caused the death of John O'Keefe? That's a firm no. We don't even believe that there has been a vehicle introduced by the medical examiner, Irene Scorti-Bello. We know that Dr. Wolf, neurosurgeon to the stars of Miami, okay, to the Golden Girls, neurosurgeon to the Golden Girls in Miami. He believed that it was most aligned, the injury to Officer John O'Keefe's skull and his brain, the catastrophic brain injury, he believes was caused by a fall. Never one time did he mention a vehicle in all of his testimony. Stop. Woo! Be still, my heart. Oh, thank you, Parksy. It's Dracula. Yes, our 4,000-year-old Transylvanian. And two, the second element was that the defendant intended to unalive Officer John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known. Oh. And this is the prong, loveys, in which the Commonwealth has tried to use against Karen Read, because will they say it was intentional, grievous bodily harm? No. The prong in which they're using is that any reasonable person would have known that what they were doing, i.e., allegedly putting her car into reverse at 24.2 miles per hour on a snowy night in January, could cause the death of another. And could have known or created a plain and strong likelihood that death would result. I'm going to say no. That's a no, Scott. All of it is a no. So on the top charge, murder 2, I think we are collectively saying, oh, we have something in our pocket for you, Commonwealth of Massachusetts. And oh my gosh, I found it right there. That's where I found it. You have not proven a GD thing to us. Oh, thank you, May. May knows. Oops. Val says hard no. Hard no. Also, Val, just wanted to say thanks from the bottom of my heart, babe, for fighting the trolls with me. Ooh, we're trying one day at a time, fighting those trolls on Twitter. Oop, turn it up. Turn what up, babe? Turn down for what? Yeah. And then Stephanie says, haha, I did that to my kids all the time. There we go. And Mrs. Parks you're welcoming all of us. I love it. All right. So here is oh, no, it isn't. The verdict slipped. Okay. For Commonwealth v. Read, this is offense 001, murder in the second degree. In the above entitled case, we, the jury, say that the defendant is, it's a not guilty from Nurse Kim's chat. Just saying. We've got 1,195 loveys in here that are saying, that's a firm no for us. Not guilty. Thank you. And this is unanimous decision of all 12 members. Sign it. Sign it. That's what we like. I want to see it. All right. Now, if I do this. Oh, good. Okay. Then she also faces a charge of vehicular manslaughter while under the influence of alcohol. Oops. Which carries a penalty of 5 to 20 years in prison. This requires the jury to determine that the prosecution proved 5 elements beyond a reasonable doubt. Okay. So here it is, babes. Look at Judge Canoni. That she had seen Teresa recently. We can tell this was last year. It was the summer of 69 and down the Cape. I don't know. I just made that up, but it felt right. She was knee deep in clams and everybody was happy. She was singing Bryan Adams and she thought she wouldn't have to come back, but she's back. And her split ends tell us a tale of maybe some stress, some things that have gone on. We're all feeling that way. Judge Canoni. I too have a tale of split ends. First, the defendant operated the motor vehicle. Do we think that the Commonwealth of Massachusetts has proven an element that Karen Read operated a motor vehicle? Yes, I do. I do. I'll give you that one. You've got one prong from Nurse Kim, you fucks. All right, we have to make it even. We're gonna do it right. If we're doing it right. You know what I'm saying? All right, one prong. No thongs, all prongs. That's what she said. Second, that she operated the motor vehicle upon a public way or in a place in which the public has right of access. What do we think, lovies? Did she operate that motor vehicle on a public way? I'm giving it. I'm giving the prongs. Thank you, bubbies. Oh, delivery. Diet Coke. He's a good man. Thank you, Mr. Nurse Kim. You shall be rewarded in your next life. Okay, so we do, yes, we'll let him have it. Gray space, I'll allow it. That's happening. And then third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. Oh. Well, we wouldn't be having this talk if we had been drinking Diet Cokes. But we are here. There is video of Karen at the bar, and she is sipping the drinks. So is she under the influence of intoxicating liquor, because that's liquor by nature? It's naughty by nature. And or, so it doesn't have to be both. It's an and or. The percent of alcohol in the defendant's blood was a 0.08 or greater. I have to give them that one too, lovies, because it's on video. She was under the influence of intoxicating liquor. If it said, and the percentage of the alcohol in the defendant's blood was greater than 0.08, I would say no. But because it's an and or, I'm going to give it to him. Yeah. Don't worry. We're calling it like it is. So we're saying, all right. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. That the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood, not a small degree, a slight chance because you had a beveragino, a high degree of likelihood that substantial harm will result to another. No, I'm not giving it to him. Yep. Look at my lovies. Nope, nada. Gray space, hell no. STH, nah. Stewart, nah. Melanie, great question. Why do they make it this hard? Because they're walking assholes, babe. Because why wouldn't we have 5 prongs that have to align and configure to 88 gigawatts and get our asses tucking and rolling? Of course, let's just make it a clusterfuck of unknown proportion so that people screw it up, right? If you have a possibility of making things more complex, the Commonwealth of Massachusetts says, let's go that way. Do you know that Peter, lawyer, told me, well, he didn't tell me, he told us, that in Florida, they have their their prongs and their verdict slips are check yes if you like me, check no if you don't. Like, there is no lesser included bullshit. Like, they keep it simple, stupid, because they do not want to, give people anxiety or make it more complex than it needs to be. The Commonwealth is, a pilgrim state. We are the people, we're from the Mayflower, right? It's the Pinta the Santa Maria. We are just thinking to ourselves, could this be a problem? If not, I'd like to make it one. You know? Let's make this as complex as humanly possible. Should it be arithmetic? No. Okay? We want a common core this and make jurors feel like the only answer is somehow going to find someone guilty. Okay. And the fifth element is that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Whoop, that's a firm no. It is a firm negative from us. All right. So on count one, we're doing an actual poll here, guys. Count one, they have nothing. They didn't meet anything. Count two, we're giving them 3 of the 5. But I'm going to tell you this, that the fourth, that the defendant operated the vehicle wantonly or recklessly as to create a high degree of likelihood that substantial harm would result to another. It would need to be, I don't know what it would need to be. The Grinch would need to steal Christmas in order for me to get there. With everything that we know about this case, and if it's true that the Commonwealth only has Judson B. Welcher left, if that's it, if he's it, no way, no how. And the fifth, that by such operation of that motor vehicle, that the defendant caused the death of Officer John O'Keefe. It says John O'Keefe, not officer, but I always put it in. You're never going to get me there. And why I say that is because you couldn't get our medical examiner there. You couldn't get Dr. Irene Scorti-Bello to the fact that the motor vehicle of Karen Read's caused the death of Officer John O'Keefe. And if you're realistically looking at the expert of a neurosurgeon, he's stating that Officer John O'Keefe, even if struck by said vehicle, what ended his life was the blunt force impact injury to the right occiput of his skull, LOVEYS. And that has never and will never be from Karen's Lexus. Even if Officer John O'Keefe jumped out of the way of a moving vehicle, did not get hit, but he leapt in a single bound, tripped over a tree, a root of a tree, and smacked his head, that's an accident. That is not a homicide by definition. So I don't think you're ever going to get us on count 2, in my opinion. Miss Jess NB, she hits it with the truth. Bring on our fellow sleeve queen Stonebridge. Jess, how much am I chomping at the bit to see Dr. Stonebridge? She is worth the wait. Bring our green goddess up to Dedham. We're going to tell her she's so smart and pretty. And she is going to tell the tale of what happened inside Officer John O'Keefe's brain and the traumatic injuries that he sustained. God rest his soul. Like, LOVEYS, I've told you this on multiple occasions, that it literally broke my heart I was, like, moved to tears after hearing Dr. Stonebridge last year. I was like, I because she's so precise and good with the way in which she explained it, but just to hear what had happened just was too much for my heart to bear. Oh, and Tori says, when said and done, let's hope this somewhat younger jurors have common sense and will challenge these charges. Tori, that is such an wonderful observation, Lovey. So last year in season 1, it was an older jury. Now, I never went to court. I didn't get to see them, but, what we heard through the grapevine, right? From either Turtle Boy or from, Jess Machado or even Ted Daniel, like, what we knew, it was that they skewed older, and I find it to be kind of a risk that was taken by the prosecution to allow such a young jury. Like, babes, when I'm telling you, at least half of them are younger than me. One of them, I told you, I might have had him. If I didn't know that he was not my son, he could have been my son. In my mind, he turned 18 in March this year, right? No, I lied, February, because that's when it went out, right? The when the summons went out, and he had just turned 18. Sure as shit, he's, like, in the batch, right? And he's like, "Oh, I'm gonna figure out I'll get out of this," right? But unfortunately, he took a skip year. All right. He took a year to discover himself. He is going to like Antigua in August. He's backpacking. He's staying at a hostel. All right. And unfortunately, he gets to jury selection and he's sitting there and he had a girl on his mind. He was like, "Oh, I'm going to call Samantha when I get out of here." Long story short, he gets chosen. Oh my God. He's just a baby. He's like Dedham High School, class of 2024. He did not want it, you know? He plays baseball in my brain. And he coaches youth hockey. He goes back, he gives back, he goes to the rink and he's like, "Hey, little Jimmy." He's just adorable. He's a good kid. He was an Eagle Scout. So, he does a lot of things. He's a good kid, but he didn't know how to use, his wiles of being an adult. He didn't realize he could say, "I have ADHD, I can't be here," because he does. All right? He is looking everywhere. He hasn't been focused, not one day. He looks next to him, his neighbor writes notes, and sometimes he checks the notes and says, "Am I paying attention enough?" But he does really like when Alan Jackson is talking. He listens. He comes to. He wakes up out of his trance. He goes, "Oh, oh, I'm here." Right? He's adorable. Oh, and then okay, so then there's, like, girls that are very young. Then there are, like, I would say maybe 3 around my age. Like, I guess I'm middle age. Oh, I'm sorry. Middle aged is I am that. Deep breaths. Breathe through it. Yep, a couple of middle-aged bitches. And then there are, I would say, maybe less than 5 over the age of 50. Oh, isn't that something? Isn't that something? Miss Jess, are we not well, you're only 38. I am 39. What? I think I'm middle-aged, though. I think it's it. I think 35 is middle-aged, no? I don't know. Oh. Oh, Annie from Southie says, "I'm 65. I must be older than shit." Annie. Annie from Southie. No. I'm so sorry. I didn't mean that. I didn't mean that. I just meant like middle like, I thought like I don't know, I thought like 35 to 65 is the middle. Is it not? Are you like young 0 to 34, then you're in the middle, and then 60, 66 and above is like when you're, whoo, you know? You're on that last, I don't know, inning, quarter. It's only 3. And Carly, I also love Annie from Southie. That is incredible. STH hits us with today's 60s are the new 40s. I like that. Okay. Let's keep that energy, babe. I love it. Oh, well, that's beautiful. Who is this? Oh, who is this little angel? Oh, somebody just said I look at least 45. Love it. Thank you. I'm gonna time your fucking ass out, and you are not invited back. Thank you. Anywho, now let's move on, lovies, to the third charge. Jurors may also convict Read of 2 lesser oh, I lied. We're still on the second count. Why? Because that would be too simple. Jurors may also convict Read on 2 lesser included offenses without finding her guilty of the greater vehicular manslaughter charge. The Commonwealth may prove the lesser included charge of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor, Cannoni said. Cannoni also said, you may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. Oh. Okay. So what they're saying here, babes, is that you clearly can't have the manslaughter and then the motor vehicle homicide. You got to pick one or the other. If you're not convinced about the manslaughter, you can be convinced beyond the reasonable doubt that it is motor vehicle homicide. Oh, we got to look at this now. Son of a bitch. All right. So here was the verdict slip heard around the world. We remembered that it had to get changed. Why? Because Alan Jackson is correct at all times, and Judge Cannoni had to change her ways. She had to go talk to a friend, a higher up, okay? She called a Raj, and it's not an Indian friend. A Raj is a higher person in the courts that is going to tell you. They probably called her. They put her on. They were like, Ballsworth, Mr. Bigglesworth. That's what they said. Get your shit together, Beverly. And you need to fix this slip. So, offense 002, manslaughter while operating a motor vehicle under the influence. In the above entitled case, the defendant is not guilty of the offense as charged, manslaughter while operating a motor vehicle under the influence. Check one or both of the following. Oh, now I'm lost. Manslaughter while operating a motor vehicle under the influence of alcohol and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater, which we would never find that. So if we don't find that, then we move to the lesser includeds. Involuntary manslaughter and guilty of lesser included charge of motor vehicle homicide, felony OUI, liquor, and negligence, which is check one or both of the following of motor vehicle homicide by operating a motor vehicle under the influence of alcohol, or motor vehicle homicide by operating operating a motor vehicle with a blood alcohol of 0.08 or greater. Okay, now I need to look that up. All right. So motor vehicle homicide, Massachusetts. Okay. In Massachusetts, motor vehicle homicide can be charged as either a misdemeanor or a felony, depending on where the driver was under the influence and the nature of their operation, reckless or negligent. Misdemeanor charges carry a maximum penalty of 2.5 years in the county jail. Oh. While felony charges result in up to 15 years in a state prison. Misdemeanor vehicular homicide applies to the driver's operation was negligent or under the influence, but not both. Oh, so that's the either or. Okay. The penalty is imprisonment in a house of corrections county for not less than 30 days. Oh. And up to 2.5 years and a fine up to $5,000. Felony vehicular homicide is this charge under General Law Code 90 applies when the driver was under the influence of alcohol or drugs and their operation was negligent or reckless. The penalty is imprisonment in the state prison for not less than 2.5 years and up to 15 years and a fine up to 5,000. There is also a mandatory minimum of 1 year in jail. The elements of the offense to be convicted of either misdemeanor or felony vehicular homicide, the prosecution must prove beyond a reasonable doubt that the defendant operated a motor vehicle on a public way. We'll give you that one. All right, we're doing lesser includeds now, babes. Lesser included. And this is, what are we doing? Motor vehicle, MVH. Okay, MVH. All right. On a public way, their operation was negligent or reckless, and their actions directly caused the death of another person. Okay. So she was on the public way. But I don't agree that her action was reckless. Do we believe that she no, okay, Carolina, yeah, all right, no, we're saying no, she wasn't reckless, right? They have not proved that at all. Negligent or reckless. No, I don't agree with that. So they only get one from us there, and their actions directly caused the death of another. No, we're not co-signing that. Oh, all right. Well, okay, so we've got one element met as a group. As the LOVEYS, we say one